Hello guys, my name is Amaan Ahmad. I'm a legal intern at LEXIS and Company, and I'm pursuing 3 years law for faculty of Law Delhi University. And the topic of today's video is the history of Constitution, or how the Constitution of India and the Supreme Court has evolved. Specifically, Supreme Court has evolved since 28th January 1950, or since we got independence. So on 28th January 1950, 2 days after India became a sovereign democratic republic, the Supreme Court came into being. The inauguration took place in the chambers of princes in the Parliament building, which also housed India's Parliament, consisting of the Council of State and House of People. It was there. It was here in the Chamber of Princes that the Federal Court of India had sat for 12 years, from 1937 to 1950. This was to be the home of the Supreme Court for years that were to follow until the Supreme Court acquired its own premises. The inaugural proceedings were simple but impressive. They began at 9:45 a.m. when the judges of the Federal Court, Chief Justice H.J. Kania and Justice Fazal Ali, Justice Patanjali Shastri, and Justice Chand Mahajan, and many other judges took their seats. In attendance were the Chief Justice of the High Court of Allahabad, Bombay, Madras, Orissa, Assam, Nagpur, Punjab, etc., or even the East Punjab states, the Hyderabad also, along with the Attorney General of India, M.C. Setalvad, were present with the Advocate Generals of Bombay, Madras, Uttar Pradesh, Bihar, East Punjab, etc. So present too were Prime Minister, other ministers, ambassadors, and diplomatic representatives of foreign states, a large number of senior and other advocates of the court, and other distinguished jurists, taking care to ensure that the rule of Supreme Court are published and name of all the advocates and agents of the Federal Court are brought on the rules of the Supreme Court. The inaugural proceedings were over and put under the part and record of the Supreme Court. So after its inauguration on January 28, 1950, the Supreme Court commenced its sitting in the part of Parliament House. The court moved its present building in 1958. The building is shaped to project the image of the scales of justice. The central wing of the building is the central beam of the scales. In 1979, two new wings, the east wing and the west wing, were added to the complex. In all, there were 15 courtrooms in the various wings of the building. The Chief Justice Court is the largest of the court, located in the center of the central wing. So the original constitution of 1950 envisaged a Supreme Court with a Chief Justice and 7 Pizine judges, leaving it to the Parliament to increase this number in the coming years. So in early years, all the judges of the Supreme Court sat together to hear the cases presented before them. As the work of the court increased, the arrear of cases began to accumulate. So Parliament increased the number of judges from 8 in 1950 to 11 in 1956, then 14 in 1960, then 18 in 1978, and so on, and the 31 in 2008, which is also the current extent, but now the strength by a recent amendment has increased from 31 to 35 also, including the Chief Justice of India. So as the number of required justices has increased, they may sit in a smaller bench of 2 and 3 coming together in the large bench of 5 and more when do require to do or settle a difference of opinion or controversy, or a point of constitution, a conflict of constitution, or its interpretation. So then the more judges will sit. For example, if Kesavananda Bharati case also, the court sat with the highest number of judges and a single bench. So the situation can vary. So Supreme Court of India compromises the Chief Justice and not more than 30 other judges at that time appointed by the President of India. Supreme Court judges now retire attaining the age of 65 years. In order to be appointed as a judge of the Supreme Court, a person must be citizen of India and must have been at least 5 years a judge of High Court or 2 or more such as courts in succession, or an advocate of High Court or of 2 or more court succession, or at least 10 years he must be with the opinion of President, or a distinguished jurist even can be. So provisions exist for the appointment of the judges of the High Court as an ad hoc judge of the Supreme Court, and also for the retired judges of the Supreme Court or High Courts to sit and act as judges of that court. So the Constitution seeks to ensure that the independence of Supreme Court judges in various ways. A judge of the Supreme Court cannot be removed from office except by an order of the President, passed after the address in each house of the Parliament, supported by a majority of 2 total majority of the House, and by the majority of not less than 2/3 of members present in voting. So it is a very complex and cumbersome process. So any judge of sitting judge of Supreme Court has never been impeached. So and presented to the President in the same motion for such removal on the ground of proved, only the 2 grounds can be there. So proven misbehavior or incapacity. So a person who has been judge of Supreme Court is debarred from practicing in any court of law or before any other authority in India. So the proceedings of the Supreme Court are conducted in English only. Supreme Court rules of 1966 are framed under the Article 145 to the Constitution to regulate the practice and procedure of the Supreme Court. So now the Supreme Court has the Attorney General of India, who is also appointed by President of India, as given in Article 73 of the Constitution, and holds office during the presence of the President. He must be a person qualified to be appointed as a judge of the Supreme Court. So it is a duty of the Attorney General to give advice to the Government of India upon such legal matters and perform other duties as which is given to him by the state. So in discharge of his function, the Attorney General is assisted by Solicitor General, four other additional Solicitor General. Then Supreme Court advocates are mainly three in classification. First are the senior advocates. There is a senior designation given to them. So these are advocates who are designated as senior advocate by the Supreme Court of India or by High Court. The court can designate any advocate with this country as senior advocate. If in its opinion, by virtue of his ability standing at the bar or special knowledge or experience in the law, the said advocate is deserving of distinction. The senior advocate is not entitled to appear without an advocate on record in the Supreme Court or without a junior in any other court or tribunal in India. He is also not entitled to accept instruction to draw pleading or affidavit, advice on evidence, or do drafting work of analogous kind in any court or tribunal in India, or undertake conveyance of work or of any kind whatsoever. But this prohibition shall not extend to any setting such matter as offered in a consultation with a junior. Then is the advocate on record. Only those advocates to file any matter or document with the Supreme Court of India, they will only file an appearance to or act for a party in the Supreme Court. Then there are other advocates whose names entered in the role of any state bar council mentioned under the Advocates Act of 1961. Thank you. That's all I want to say in this video, and thank you. And please remember that video does not violate any guidelines of Bar Council of India. It does not solicit or promote any of the content. The sole purpose of this video is educational. Thank you.